Добрый день.
Good morning, good afternoon, dear colleagues. Let us start our session. Some of our speakers will come a bit later. We have a global and a very extensive theme, and judging by the experience of the previous years, 2 hours are not enough, and we have 1 hour and a half, after which we are going to have lunch according to our agenda, so probably we'll start. My name is Alexandra Pahomov. I represent Inter-RAO US company. I would like to thank the organizers of the forum to organize the round table on this urgent theme on the development of the legal model of the electricity market, tensions and search for compromises. The theme is quite extensive per se. The industry is system forming and also extensive. The main regulation period in the sector was at the end of 2007, 2008, and currently the process is underway. This is a very long-term and painful process. I understand how often I visited RAO US of Russia, and we discussed the issues of market modeling, capacity, commodity, non-commodity. Now there is no doubt among the lawyers that power and commodity, they're not trying to speak about it now. In the past years, in the past 4 years, the new system has been set up of wholesale and retail electric energy markets. So we have overcome the threat of deficiency of electricity. There was a significant reduction in the objects of tariff regulation, and significant time and focus is placed on the matters of energy efficiency, energy saving. Nevertheless, at present, we are at the stage when we have passed the first stage of regulation, and we have outlined the challenges which never faced us before, or probably they were not taken into account before at the first stage of development of the first wholesale electricity market and capacities. And it is obviously which the questions which we have to solve today are systematic, and for us and lawyers, as lawyers, who play an important part in the process. Probably the economy takes the lead in building the relations between legal model and market, but the search of the legally efficient technologies of normative regulation is quite important. That will establish the new model of the market. Nowadays, part of the problems and judicial disputes and contradictions between the market subject are, so to say, white spots in normal legal regulation in our sector. And quite often there are norms which contradict each other and the regulatory acts of different levels. We tried to invite to our discussion representatives of the departments and ministries that are responsible for building the model of the wholesale electricity market and powers, our international colleagues that will share the international experience of regulating markets in Europe, and probably our main purpose today will be to find the legal technologies and options of resolving the current problems that have been accumulated by now. Of course, we won't be able to solve all the problems. However, in the course of our discussion, in addition to the presentation of our speakers, we should also concentrate on the matters related with investment attractiveness of the industry, because currently the deficit of capacities or the lack of investments in the sector create a serious threat with respect to development of long-term, with respect of the long-term market development model. We also suggest that we should discuss the issues of non-payments at the market. The situation at the retail markets of electric energy and capacities is not simple at present. And of course, special focus should be placed on liberalization of the electricity and capacities market that has been ardently discussed lately based on the models of Yuri Udaltsov and the Union of Electricity Producers. And in this context, it would be interesting to discuss the problems of access of consumers to the wholesale market, consumers of electricity and capacities, the contracts on delivering capacity and commercial use of the capacities. I will introduce the participants of our discussion. That is Anastasia Bondarenko, Director of Law Department of the Ministry of Energy of the Russian Federation, Andrew Petrie, Partner Siemens & Siemens, Arno Willems, Partner Sidley Austin LLP, Ivan Stepanenko, Deputy Head of the Legal Department of the Federal Tariff Service of the Russian Federation, Vitaly Korolov, Head of the Electricity Industry Control Department, Federal Anti-Monopoly Service of the Russian Federation, Alexander Sitnikov, Manager Partner Vegas Lex, Oleg Shelakhovos, Judge Supreme Commercial Court of the Russian Federation, Vincent Deru, General Director for Nietzsche Rus EDF Group. Probably will first give the floor to the Ministry of Energy. As a ministry that is responsible formally, officially, de jure and de facto, for building a new model of the wholesale market, a new and improved model. Thank you, Alexander. First, I would like to thank for the possibility to take part in this interesting roundtable discussion with that interesting theme for many of us, for us in particular. And I would like to thank our colleagues for having come here to listen to these presentations on that interesting theme. I would like to apologize because my presentation is unfortunately will be in very small letters, and I never thought that the screen will be of this size. We suggest in the course of the discussion to dwell on the most problematic issues according to the Minister of Energy, to the most disputable aspects of norm making in the sphere of energy that is based on federal laws, acts of the government, and departmental acts. These are three main levels of legal acts while preparing or amending which we come across a great number of challenges. From the legal service of the Ministry of Energy, I will dwell on legal issues. The law on electric energy is the fundamental act, I believe, to the relevant norms. Most of legal relations regulated by the law in a certain way were worded for granting to the government the authority on regulation of the legal relations. Here we come across the main statement of the Russian law based on the requirements and constitution requirements of the civil law. The civil rights of economic entities might be restricted only on the basis of federal law, only for the purposes which there are three purposes: protections of the fundamentals of constitutional constitution and defense of the state and security of the state. So taking the decision of approving the act of the government restricting the rights of the economic subject, we should ask a question whether the restriction complies with the above purposes. I think that when we design the norms, we not always remember it. The next slide deals on the problem of the law on electric energy, the gaps in regulation. The gaps in regulation that problem ensues from the fact that certain relations are not regulated, that have to be regulated at the level of the law. After that, these relations are found in different documents regulating legal relations of the parties, acts of the government, contracts on becoming members of the wholesale market. Are there any decisions taken concerning that these norms are not in the laws but in the by acts? I think that we have to improve the legislation, starting with the law, so just the examples of the questions are given in small letters that need regulation. For instance, the organization might be deprived of the status of the guaranteed supply, or the establishment of the scheme of the subjects, and that is provided for the federal levels, and the legislation on counteracting corruption, the methodology of anti-corruption expert examination to each subject, filling the gaps at the regulation without delegation of the authority is a corruption factor, and this lawyer designing the norm should take that into account and try to avoid it. Besides, there are problems in regulation related to contradiction of the bylaws of the government to the acts of the higher level, not only Law 35, but Civil Code. For instance, there is a direct contradiction. The rules of technological connection, you should be aware of these regulations. The applicant has to approve the documents with the designing organization that contradicts the construction code, which states that it is not allowed to coordinate these documents with these organizations. Bylaws of the government have the norm that is quite debatable, and the lawyer should decide whether it complies or contradicts the law, or whether it is beyond the limits of the competence of the government. If it is beyond the limits of the competence of the government, that is regulation and filling of the legislative gaps, we think that a great number of legal relations in the sphere of electric energy in the acts of the government has no legislative regulation, and there is a lot of assessment based on the agreement of connecting to the wholesale market and the possibilities for the creative activity in the sphere of improving our regulatory base is available. Another problem related to acts in electric energy is the retroactivity. Retroactivity, that is regulation of relations at a previous date. Unfortunately, that is often recorded, and the approaches are quite different. As far as I understand, the judicial practice divides the approaches. That the norm that is formulated in a blanket way is illegal if a certain event is mentioned and its consequences are mentioned related to the previous date. If something happens in the past and the consequences are recorded in the past, there is a certain qualification of the norm with the date of that norm coming into effect. That is an illegal construction that has to be avoided in the course of designing and acceptance, and while preparing and development of the acts. I should also mention the respected colleagues, including those who attend this meeting. Interaction of federal authorities while preparing the acts is related to violation of the regulations. In my slide, there is a flag that all the layers violate the regulations while preparing the acts for the government. I mean the Ministry of Energy, by all the parties, and I ask you, my colleagues, to observe the regulations when you develop these legal acts. Taking into account the short time of my presentation, I will briefly characterize the model of the current wholesale market and the markets that are currently discussed as to how we'll proceed in future. The current wholesale market object is characterized by the fact that the main incentives to invest into the generation objects is the so-called DPM or provision of the capacities. Most of the energy is sold at the spot market, and most of the capacities are sold for the next year. The mechanism of guaranteeing the investment is not functioning, and the risk of deficiency of the generated capacity is determined by the desire to become members of the DPM list. That is a current model which has its specific characteristic. Currently, the basic two models are discussed by the Minister of Energy, and the third edition model, and I will show them in the next slide. So model number one, this is the current model plus the new DPM. Specific features. It is planned that a new DPM program will be introduced, an instrument of regular incentives for the project of new construction and upgrading of the generating equipment. It is kept as the main instrument for planning and qualification of the generating equipment, and there is a reduction in the zone of free overflow of energy, and there is a correction of the pricing in the course of COM. So what effect of the model will be attained? Of course, there should be no deficient of generation capacities. The risk is also clear. The construction, the building of the capacities will that at an exaggerated price in places where they are not needed. A second model is called the model of free bilateral agreements, market model. Whether we'll come to it sometimes, the main mechanism of trade, free bilateral agreements, mechanism of direct return on investments, and development of all types of contracts, including standardized forms, and with the main emphasis, and the basis of the market are financial agreements on delivery of energy with the capacities. What is the effect of that model? Doubtless, that is attraction of the investments for building the object with the lack of new DPM, the creation of incentive for the sellers for reduction. And this is a major problem. First, that is a risk of growing prices. Secondly, indefiniteness, as was mentioned by Alexander, whether one commodity will remain electric energy or there will be two commodities, electric energy and capacities. So that is the second model. The third model that has to be mentioned, it is more balanced or more careful. Probably it will be considered quite seriously. Probably finally they will choose one of the first two models. The third model is a long-term taking of COM. A passage to the long-term COM with a delivery date in 4 years, so that the upgrading process of the facility will start direct competition between the existing power stations and the designs of new construction and upgrading of the generating objects, increase of the time of payment for the capacities from 1 year to 7 years. In addition, minimization of the power delivered in the regime, the excessive power needed for catering for the demand. The effect it will provide the most effectively economically efficient generating facilities, and the problem is that the market will become under such rules fully regulated, so the decision on the economic and technical grounds will be taken by the federal authority that would approve it, including the state, through the packages of participation. In many cases, the risks of inefficiency will be incurred by the end users, in our view. And I hope that I have kept within my time limit. I would like to stress that the current model or the choice of the new model, when we have the acting model, will be done in 2013. Most likely, the government will determine how the market will proceed, despite the fact that everyone participates in discussion of the model. When the strategic vector of movement is developed, then the text of the regulatory acts will be developed, and the lawyers will have to take care of the errors listed in the previous slides so that they will be omitted from these new regulations. Thank you for your attention.
Thank you, Anastasia. You've been very brief and up to the point. We'll go the following way. First, we'll give the floor to our foreign colleagues who will tell us a couple of words how this particular energy model is organized in Europe. And after that, we'll launch a mini Q&A session for the two speakers in order to find out the differences between the Russian and the foreign models. Now, it is my pleasure to give the floor to Arno Williams, who's the partner of the Sydney Austin company, and he will tell us about the European energy market model. Arno, my question to you, my request actually to you, I know that Russia is one and it has one model, singular model, and I know that Europe is a big country and there are several models, but even though you have 10 minutes only.
I'm very happy to be here and to share the European side of the story. Indeed, you rightly say that there are many systems in Europe. If you look at Europe, you may think it's one political union, one economical union, one market. But for electricity, there still has to happen a lot before we have really one electricity market. And I see some similarities with the Russian system, but I suggest I go through this and then we tackle the similarities and differences in the Q&A. This is basically the result. This is too small to read, but the main point that you have to take away here is that the energy prices for industrial users in Europe range between basically 8 cents per kilowatt hour in Bulgaria and up to 22 cents per kilowatt hour in Cyprus, which is a big difference. And the difference is, of course, caused by also factual circumstances, but also by legal circumstances. And the problem that Europe has with this system is that in this case, you cannot really have an internal European market, because this means that a steel producer in France may have a very competitive advantage compared to a steel producer in Germany, simply because of the energy price. And that is one of the reasons that Europe really puts effort in this European energy market. Recently, this was recognized by the President of the European Commission, Barroso, who really tries to ignite or start the debate a bit more aggressively, because it's all going very slowly so far. And he really tries now to mobilize the people. Now, what do we need to get one European energy market? Basically 4 points. In view of Barroso, we need more power to the EU. Until the Lisbon Treaty in 2011 or 2009, sorry, we were without powers. The EU was without powers to do much. In 2009, there were a couple of things in the Lisbon Treaty that gave powers to the EU. We need more or better regulation and enforcement. We need more competition, and we need investment. Now, to go here, so the Lisbon Treaty in 2009, energy was for the first time mentioned as basically a competence of the EU. But still, it's only a shared competence. It's like taxation. In Europe, there are different taxes in all member states, and that's the same with energy. That means that there will be a requirement to take decisions by unanimity. That means that all the 27 European member states have to agree to energy legislation. So that's quite a high hurdle before you can get any real legislation done. Now, then you have 3 types of European regulations. You just need to be aware of it. You have European regulations that have direct effect. You have so-called directives that need to be implemented in national law. And there we go, because everyone implements all those rules in a different way. One of the main instruments for the European electricity market is the Electricity Directive that has to be implemented in 27 member states. Not everyone is doing that in the right way, and not everyone is doing that in a timely way. And then, of course, you have the national rules that have their own policy background. So some people may want to stimulate renewable energy. Some people want to ban nuclear energy, and that, of course, has all consequences for the price levels. Now, initiatives from the European Union, they have made an energy roadmap to come really to a fully integrated and efficient energy market in 2050. That seems far away, but in view of what has to be done, it's pretty close, I think. Other targets are 2020, they need 20% renewable energy. In 2015, they want that there are no longer any member states isolated in Europe. That means that all the member states have to be connected to each other and have to be able to trade electricity with each other. And in 2014, which is next year, they really want already the completion of the internal energy market, so that everyone has implemented all the European rules. And that's quite a task. Now, if we look at the regulation, basically for electricity, I have here the same problem as my colleague. The letter fonts are a bit too small, but there are three big packages of legislation. The first package was in 1999 and was really to reshape the electricity and deregulate the electricity sector. General organizational rules starting to liberalize. Then we had the second electricity package in 2004. That meant basically that the first package was not good enough, where basically a push was given to the liberalization process and more specific rules were provided. And then we got the third package, again only 5 years later, which really focused on an improvement of the competition aspects especially. So they created a European regulator, they created more common rules, they created improvements to the unbundling system and the access to the network system, so that the supplier and the distributor of energy are two separate legal entities who are not related, and that everyone has the right to access to the network. Now, if we are speaking about the competition, because that's one of the more interesting things, how do they try to get that done? Basically, they want to couple markets. They cannot get all the 27 markets together in one go, so they want to couple a couple of markets together so that the market is bigger, that you get more price pressure, and they are creating regional markets as a step towards this big 27 market. That should be one. And we see already the results. We see basically that as a result of these two initiatives, the price fluctuations for electricity have been much less than the price fluctuations for instance, oil or gas. 3 times lower price fluctuation. So it's a considerable effect that this measure basically had. We also see that the prices went down a bit, and we also saw that decisions in the market were more price-based than before. So this is really the start of the one big market. The second part is that they really introduced national and European regulators. So they have the Agency for the Cooperation of Energy Regulators, which is a European-wide regulator looking into or supervising basically all the national regulators and laying down the right rules for third-party access rules or third-party access to the network, for capacity allocation, for network codes, for the balance of the system. So really a very important harmonizing function. And next to that, the European they created a European network of transmission system operators in electricity that became much more independent from the state where they were based in than before. Then we had the unbundling. So companies, basically national monopolies were broken down. Companies were no longer allowed to produce and distribute electricity. And you can do that in various ways. And what we have seen that there is most people took a legal route, so they didn't divest, but they found a legal solution to unbundle. And what also was something that they imposed is that consumers have the right to change suppliers, and also that gave quite a price push. Now, problem there is the enforcement. All those rules are very nice, but how do you enforce? And there we see that a lot of the member states have problems, and basically what you see is that the European Commission is now taking action to enforce this. So what have they done? They have started 19 infringement cases. So they have sued 19 member states basically for not implementing the energy regulation correctly. And that it can have consequences is clear because certain countries, Bulgaria, Estonia and the UK, have received fines for not implementing the rules. And until they do this, they have to pay between 5,000 and 150,000 euros per day. That's quite something. Last point on investments. We have to come to investments. 1 trillion by 2020, of which about 140 million in the energy sector. There are 3 models: a private model, a TSO, transmission system operator-led model, or a public fund. The thinking is to go to the public fund. I'm happy to discuss the background behind this a bit later, but in view of time I will not go too far in this. Examples of what has to happen, and then basically lessons learned, what I think that could be useful for Russia to keep in mind is that a legal framework is one thing, enforcement is a second thing. You need investment, you need really to think how to get the funds into the system, and you need to address the right technical things, because technical bottlenecks can limit the cross-border trade, but the commercial bottlenecks can stop the trade entirely. So you have to find this commercial trigger. And that's basically what I wanted to say today.
Спасибо, Arno.
Thank you very much, Arno. We understand that you have even more regulators in Europe. We have only one, and you have much more than that, 27 plus 1, 28 already, if you do your own math. Now, I'd like to give the floor to Petri Andrew, who is the partner of Simmons & Simmons Company. May we please pass on the pointer to him. Спасибо большое, Александр. Спасибо большое за ваше краткое описание.
In a way, I guess I'm going to take a step back and look through the other end of the telescope to perhaps put where we are in Europe in context. I have some slides. I'm not proposing to go through them in great detail. You may find them interesting to give a pretty full view of what regulation, utility regulation, looks like in the UK. I'm going to just look at one slide and talk about that because I only have 10 minutes. Why is the UK interesting from a point of view of a country that's trying to develop an energy regulatory system? The reason for that is that the UK led the world in moving away from what had become the norm in the mid-20th century in the West, which was a mixed economy where the utilities were almost universally in the hands of state-owned entities, and were the policy and the implementation of policy was entirely public sector-led. That situation, I think, probably arose out of the responses to the 1930s economic crisis and particularly against the command economies that were created during the Second World War in order to mobilize resources. It had ceased working for the UK, at least, in the 1970s, and there were economic theories being developed in the United States, which Margaret Thatcher implemented in the 1980s, privatization and the creation and the unleashing of private sector expertise in a regulated environment where government retreats from implementation and focuses on what governments should be doing best, which is policy and designing policy. In that process, the UK experimented, and of course, having been the first experimenter, other countries can look and learn and take the best and try and avoid the worst of what has happened in the UK. And many of the responses that are being developed or have been developed and are being further developed that Arnaud just explained at an EU level were pioneered in some respects, or indeed were adopted in some respects from what we learned in the UK. My first job as a lawyer in the spring of 1990 was reviewing something called the Pooling and Settlement Agreement, which was about that thick, which was an agreement which regulated the way in which generators could put power into the pool, which was the net in the UK, and be paid for that. At the time, there was a very clear separation between generators, distributors, and the systems operator, National Grid Corporation. That's a model which, slightly adopted, is really the backbone of what unbundling is all about. The pooling arrangements that were written up in 1990 and became current, I think, when it was privatized, I think, 94, survived for a while. They were replaced by a modified system called NETA, and then NETA itself was also amended, and a new system, which is the current system that we're using, called BETTER, whereby you have a completely deregulated market for market participants to trade electricity and then inform the systems operator what their deals are and when they're going to supply what into the pool or into the system, with penalties if you oversupply, and the ability for the systems operator to then make you pay for the cost of taking another generator off the system because you've oversupplied. Equally, there's also penalties if you do not supply what you said you were going to supply into the pool, and the systems operator has to dispatch alternative generation capacity in order to fill that gap. And that, in the crudest sense, is what has regulated and has incentivized investment in the UK since the privatization and the unbundling that was put in place by the Conservative Party in the early 90s and developed by the Labour governments that followed. What issues, bringing it up to date, have we found that have stressed that model? One of the issues that's really stressing the model is the climate change agenda, where the mix of generating capacity is completely different. Most of our renewable capacity in the UK is planned to be wind and solar. Some of you may be surprised that solar is an important topic in the UK, but it is. When the wind doesn't blow, when the sun doesn't shine, no energy is created, and therefore that highlights a topic which I believe is of great interest here in Russia, which is there a value, and should there be a value, to capacity which is not dispatched in the system? We don't have a way of incentivizing capacity in the UK market at the moment. We didn't feel we needed it because we felt the model that I just described in terms of penalties for oversupplying and penalties for not supplying what you've promised was sufficient. But now, particularly highlighted by this issue of the generation mix created by intermittent energy sources, is highlighting the need for capacity. There are other reasons. There is the wholesale expiry of the life cycle of our nuclear capacity. We have, as we just heard from Arnaud, UK is no different. We have a massive investment requirement in the coming few years. The figure is put at somewhere like, well, 200 billion sterling between now and 2020 is a figure that's often bandied about. And that investment needs to go into new generating capacity, new gas storage capacity, new transmission capacity. So for all those reasons, capacity is an issue that is high on the agenda. There is a new Energy Act being debated, and as part of that new Energy Act, it's anticipated the UK will introduce a reward for a capacity charge and reward for generators who have available capacity on standby, even if it isn't dispatched. Clearly, there are so many more details and topics that could be explored. I'll just wind up to say that you could see this in one sense, that the UK, having pioneered the unbundled free market systems that are now being applied in Europe, in some senses are stepping back a little bit from the full consequences of a totally unbundled market. And as we saw in California maybe 10, 15 years ago, if you get the regulation wrong, where they had fixed consumer prices but not the right incentives for the building of new generation capacity, you can get yourself into big problems. So I guess that's the main thing to bear in mind. Thank you.
Thank you, Petri. Now we'll give the floor to Vincent Deroule, General Director of Finichi-Rus, who will make his presentation. And after that, I will take the right of the moderator and I will ask one question. Vincent, you're welcome.
Thank you for inviting me to this very interesting session. So I represent Électricité de France, EDF Group, which is one of the main actors in Europe and in the world in electricity production. What I would like today, so I have no presentation, because what I would like today is maybe to put an accent on some aspect of the question of the regulation and capacity production, which is for me interesting, and where in Europe there are some solution, and in Russia, being present in Russia and working in Russia since the last 3 years, I see that some difficulties that could be that should be addressed in a more detailed way. Actually, what I would like to discuss is, as we know, regulation. One of the aim of the regulation is, of course, to give to the final client a good competitiveness in the price and a good quality in the service. But there is also some technical aim of the regulation, which is to guarantee to the final client that he can receive electricity because there is a good level of technical condition of the network, and it's just what we have mentioned before with what happened in California with inappropriate regulation, which leads to a, let's say, a catastrophic scenario. From technical point of view, I would say that a stable network can be obtained by a mix of different technical solutions. Of course, you must have an appropriate geographical repartition of the capacity production on the territory. And I can give you the example of France, where there is Britain, which is the west part of France, the arm, for those who knows how France is done. The west part of France, where there is very low installed capacity in this part, and it is known in France to be the weak point of the electrical network of France due to the fact that there is no or very few local capacity production. There is, of course, a necessity to have a mixed generation capacities in terms of fuel and technology, as it was also mentioned, gas, coal, of course, nuclear power plants, and all renewable energies. This mixed give also a better reliability in the production capacity, and then, of course, a better reliability in the network. And that's also why regulation is very important, to oblige people who will install this capacity to respect a certain mix of production. The last item, which is quite new but getting more and more important, is the sustainability and the impact on the environment of these existing and new capacities that can be built, which of course make even more complicated technical solution for a good regulation. So what I want just to mention today by saying this maybe too long introduction is the fact that there is one of the way to obtain something which is very close to a good solution is what we call the cogeneration plant or the small cogeneration plant, which can be can provide a good technical solution in terms of geographical repartition of the production, in terms of sustainability, because you can reach very high efficiency by cogeneration instead of pure generation of electricity, and in terms also of, let's say, economical conditions for the final client. What I see today, and that's where I wanted to arrive, is the fact that Russia is absolutely not ready, or not ready yet, to have an appropriate development of cogeneration, small cogeneration power plant that would be one of a good solution to support the let's say good quality of the network. And when I say that, I'm not only talking about some incentive that it can exist in Europe, where you have the green certificate, the blue certificate, the white certificate that will push this kind of investment to be done by let's say electricity company or by industrial companies in order to get their own production. But there are also in Russia some barriers that are preventing the development of cogeneration, which again is not the solution or the miracle to any kind of problem, but is one of the solutions to get what at the end we want to obtain is stable network, good price for the final client, and sustainable solution for the Earth, let's say. So I can mention some of the main barriers that you can face, and there are of course some let's say economical or business barrier, because it's not always well accepted to build a small cogeneration on a site, sometimes by local electricity companies, or for different reasons. There are also some legal barriers, and I will just give you an example. And probably it is a matter of discussion or a matter of, let's say, thought on what can be done in Russia to improve this kind of situation. When you want to make cogeneration in Europe, and I have in mind the example of France, Italy, and Spain, where I've been working on this specific activity. When you want to build a cogeneration and agree on all terms to build a cogeneration for a client, for example, you need to sign one contract, which is called the tolling contract. So there is a contractual framework which allows to build, finance, operate, and then have local capacity production that would help the, let's say, regulation matter. In Russia, we are trying to build some contractual framework for cogeneration construction. And what we are seeing now is that you need between 3 to 5 different contracts to be done with different entities under different regulation in order to be able to have this kind of cogeneration fully compliant with the Russian law, which is, of course, absolutely necessary. So I'm not telling that there is a solution or that there's cogeneration is a solution, but make it easier from legal point of view could be also a good solution to help easier the regulation and the technical aspect of the regulation. So it's just a few, I hope this can help us to have a good reflection and some interesting discussion on this very specific topic. Thank you for your attention.
Thank you. Спасибо.
Thank you, Vincent. I will take the opportunity being a moderator. Anastasia, I have a question to you. You said that the Federal Law 35 contains a lot of reference norms, and I know that when discussing the current models, we're also discussing this issue on relating the level of competence on behalf of the Minister of Energy towards to the benefit of self-regulated organizations, market. Do you support this approach, or do you insist that the regulation in the industry and pricing and market model should be at the level of relevant ministries and departments, and the authority which the Council has at present is sufficient? Alexander, I believe that any combination of economic subjects into self-regulating organizations and the rules of the game determined by a self-regulatory organization for them is in the plane of voluntarily decisions taken by the economic entities. I disagree with the mixing of the authority of self-regulating organizations and the public authorities. Quite clearly in our legislation there is a distinguishing of the functions of economic regulations, tariff regulators, functions of a government. Self-regulatory mechanism mean to what extent the economic subjects, by combining, by merging, delegate the rules to the Council of the Market, to the right to determine the rules of the game. So I think we have to distinguish state regulation and state interference, and free voluntary assuming the voluntary restriction of their rights within their organization. Strict framework was the key word. It is clear, so under conditions of liberalization of the market, a special role is assigned to such regulators as Federal Service on Tariffs and Anti-Monopoly Authority. Let us give the floor to Ivan Stepanenko, who is Deputy Head of the Legal Department of the Federal Tariff Service of the Russian Federation, who will speak about the further model and prospects of pricing in electric energy. Thank you very much for the opportunity to take the floor. As has already been mentioned, we are in the transition period that has already been completed, but we are adjusting some norms concerning tariff regulation, and there is a regulatory basis of the tariff regulation that is being constantly improved. First and foremost, we have to mention that everyone knows that there is a relevant trend that adopted in the country to reduce the tariff load on the end users, but we shouldn't forget about the necessity of ensuring the economic interests of the regulating organizations and the relevant investors. The task of the state is to ensure the principle of balance of interest of the regulating organization and their consumers, so that there will be an optimum combination of the economic efficiency and social justice. As for the trends of improvement of tariff regulation, they are shown in the slide. We'll detailize on them later. The main trend of improving tariff regulation is targeted and at the electric network complex. It is clear that the market on transmitting electric energy is fully regulated. It should be noted primarily that there is a modernization of long-term tariff information, and the specific role is played by Federal Law 291 that was enacted in April and made significant changes to the law on electric energy. There is a long-term tariff regulation of the prices for electric energy introduced into the technologically isolated system, so that the price would be balanced. This law provides for the authority of the government of the Russian Federation to determine the limiting indexes for the price growing with respect to the prices for each year of long-term regulation. When this regulation is determined, or when the period of long-term regulation is extended, that law also provides for restriction of the extent of financial needs that are included into the investment projects that are restricted regulated by the normative plans determined by the Minister of Energy for construction of the electric energy facilities. The indexes of reliability and quality for the investment projects are also taken into account. Taking into account all these issues, the costs are included into relevant prices. A very interesting amendment on novel provided for by the law 291 is the budgetary responsibility for the actions made by tariff regulators. I won't dwell on it in detail. There is some cases provided for instance, a change in long-term parameters, tariffs, and long-term gross revenues, as well as establishing of tariffs based on long-term regulation parameters, unlike those determined by regulators or agreed on in the concession agreements. If, as a result of such action, the revenues of the regulating organizations arise, they receive a compensation from the regional budget. From the viewpoint, from the legal viewpoint, I think this novelty is interesting because before its inaction, the regulating organization, in case of emergence of certain omitted revenues due to the actions of the regulatory bodies, they have to address to the Court of Law and receive a decision that confirms the facts of illegal tariff resolution and ask from the budget to cover the losses, determining all the elements of the excess of the loss and the causal and consequential relations. Here the model of compensation of the revenues that were not received is simplified, and the extent will be in accordance with the statement of the government, decision of the government that will be approved, and such compensation to the regulator authorities will be related not only to the effects of legal actions of the regulators, but in case they legally change certain long-term elements, for instance, when they the current law is changed. Of course, there are certain exemptions from this rule. That is a correction of the revenues provided for by the legislation, cases of the last mile, and the cases of deterioration of the economic situation, meaning crisis. As for the improvement of the mechanism of regulation of the electric network complex, here there is a major problem consisting in the following. There is a growing number of network organizations, and network organization, most of network organizations, do not have any extensive infrastructure. The problem is also related with the so-called networks that serve mono users, that is the consumers, large industrial companies, give their network on the lease to a network organization, which mainly provides the services on transmitting electric energy to that relevant company across the network. But all the expenses for maintaining the network are included into the combined network, and that is valid for the territory of the subject of the federation. For instance, now the governmental order 1178 provides for a separate tariff for such mono networks. However, there are no criteria that will determine the organization as an organization within a mono network. We, from colleagues from other departments, will try to solve this problem. And there is also a problem related to the following. There is no duty of the regulatory organization to submit an application on establishing the tariffs, and the judicial practice is such that lack of a tariff does not mean the cessation of the regulated type of activities. In this connection, it is necessary to make a change that would provide for the duty of the organization to address for regulation, for instance, within a certain time period after starting the regulated activity, and the administrative responsibility should be related to non-addressing to the regulator, and in case of the recalculation of the cost of the relevant services after tariff regulation is implemented. As to the networks, there is improvement of regulation of the payment for the technological connection to the electric networks or grids, and the relevant drafts of making amendments to Federal Law 35 are prepared concerning the reduction of tariff load on SMEs that connect to the electric networks, and the mechanisms provided for including these expenses of the organizations that are connecting these consumers into the tariff for electric energy transmission. And the draft of amendments has been prepared concerning the payment for connection to the generation facilities. The generators are now covered by the prohibition to include into the payment for the technological connection of the investment component, the so-called last mile. But for the network organization, there is a compensation procedure, but for the generators, there is a gap in the regulation. These amendments will fill up this gap.
It is also not a secret to anyone that cross-subsidizing is a problem in our country. Everybody knows about that, but as far as its legality is concerned, is not fixed anywhere. So the new law will be introduced where such term will be introduced, and the authority of our government to establish the ways of allocating these funds. Another solution to the cross-subsidizing is implementing a mechanism of dividing those capacities that are provided to cover the necessary social demand and what's provided beyond that. So the law number 35 introduces this term, and it also describes the way the government can carry this policy out. I hope that this project will soon be adopted and partially the problem that is at hand will be eliminated. I have wrapped up my presentation. Thank you very much for listening. Thank you very much, Ivan. Now it's high time for the Federal Anti-Monopoly Service to speak up, because they are the controllers, and after that we'll follow with a judicial instance. They will serve as a climax point of our discussion. They will be the terminators of the session. Okay, Ivan, the floor is yours. Good afternoon, dear colleagues. I see that our roundtable have collected quite a significant audience. It seems that the questions that are at hand are quite interesting for all of us. I would like to start off by saying that, well, I'll quickly tell you about the authorities of the anti-monopoly service in the energy market. Actually, those authorities have to be divided into two parts. Some of them are similar for all the markets in the country. What we do is we control the commercial concentration, we review various deals that can lead to commercial concentration. We also assess various commercial entities to see whether they violate their dominating position, and a number of other violations and infringements that pertain to different other markets, not just electrical energy market. But there is a number of authorities that are unique for the electrical energy market and are not presented anywhere else. For example, we can ensure the control over price regulation on the wholesale markets. This authority has been introduced by law number 35 on the electrical energy. Also, there is a special norm that says that we need to divide between those types of activities that are possible to be monopolized and those that are not. And this is related to the initiatives of the European Union. For example, when the company does purchase and sales of the energy and when transforms the energy, it can be reviewed as the monopoly activity. Now, in Russia, this norm has already been introduced quite a bit of time ago, and our agencies are monitoring whether the law is enforced. The decisions that we made or the experience that we have demonstrates that this law is being followed. Also, we can identify the zones of free electricity overflow. That is done by means of analyzing the economic concentration of those zones, and in here we work a lot with our Ministry of Energy in order to reduce the number of those free overflow zones, and we want to achieve the high level of concentration of independent participants, of the players of this market in the zone, because it will create more advantages, it will create more advantages for the market. The current trends show to us that probably by the next selection we'll have not just 23 zones, but about 10 zones of such kind. At least such discussion was initiated during the Special Committee on Energy under the government of Russian Federation. Now, as for the competitive selection of capacities, is extremely important because it creates the means for the generators to cover their fixed costs, so that later they can use various opportunities for participating in the spot market or the day after market. And as for the proposals creating one product market, in this respect I would like to say that the competition will be in place in relation to full expenses, and we shouldn't and we will not be it will not be needed to do the power selection competition, but in such a way this market will be much more rigid and the price fluctuations would be much higher, and there are certain risks that might entail if we embark upon that initiative. Now, a couple of words about our new plans as far as changes to the legal framework is concerned. Now, first I'd like to say about some things that have already been partially made, such as the roadmap on improving and making it easier to access the grid. Some things have already been done, others would have to still be introduced to the government. Now, as for mono consumers, which has been already mentioned, well, we have developed a document that covers the mono consumers. It's been introduced to the government half a year ago, and we do hope that very soon it will be adopted. Probably it will have to be modified, because today the Ministry of Energy is participating actively in amending this particular proposal. Now, we have another interesting project. It's another decree of the government that we discussed with our expert community during the Expert Council on Electrical Energy in February, and this decree fixes the notion of the single distribution spot for the region. It allows more players to participate in the wholesale market because that makes it much easier to get into the wholesale market, and there's a lot of supporters to that decision. We received more than 200 letters from the market players who said that they are ardent supporters of this particular initiative, and there's also a couple of letters that say that it's not so good. Who these letters sent to us? Mainly the generators, the manufacturers of electrical energy. We know why it is not so good for them, because they believe that we should not allow to the market the majority of large entities, and the suppliers also opposed to that, because they believe that a number of their consumers would be withdrawn from them. However, a decision is required. It might not be that cardinal and not crucial, but at least a certain decision of such extent will lead to better competition. So we will still insist that this document is needed, and we will continue to argue with our colleagues in the ministry. Now, for the purpose of subsequent discussion, I would like to introduce another topic. I will try to argue this topic, and I would like to make a case for it. Now, self-regulatory organization. The question is, how perfect is this mechanism? Well, quite recently, the Anti-Monopoly Service have initiated two cases related to several aspects. First, the fee that a participant of this non-for-profit association has to pay has been recently increased. So if you want to trade in the market and you want to participate in the partnership, you have to pay a fee. In accordance with our data, in accordance with the letters of what we have obtained, the players of this market believe that the fee is too much, and sometimes it is even larger than the profits they make in a year. We wanted to have a look at whether it is really feasible to constantly increase membership fees to the association. Another case that we dealt with just a couple of years ago and was supported by various instances that the membership fee, the upfront membership fee, has been increased 5 times fold, from 1 million rubles to 5 million. We believe this serves as a barrier. All the courts supported us, and the entrance fee also grew down back to 1 million, but again it starts going up, which is not so good. Now, another question that I would like to raise up in here, the agreement on connecting to the grid, if some of you have seen it, it's just a meter thick pack of documents. Is it really easy to read it, to understand it? And that's a question that I would like to address to the legal community in the country. So, in the framework of this agreement, it is prescribed that everybody, any new player to the market, has to create a new metering system that is that equals consumers to the wholesale market. The process have to be prolonged in time, I believe. And second, the Federal Anti-Monopoly Service, when they support better liberalization, still are not responsible for the guarantees. They're withdrawing themselves from the guarantees in the market. So we want this mechanism to be implemented only in case other regulators will strike a balance, will find a compromise for providing guarantees at the wholesale energy market, so that we don't face any non-payment crisis. Another thing that is not quite clear to me is what are the consequences of letting the consumers to the wholesale market by means of this fast lane track, because from one side we would have most solvent consumers, and from the other side we have the most expensive entities and the less solvent consumers on the other side. Will it lead to additional load on our generators, because we have such zones as Dagestan and Chechnya. So that is the question. Can you comment on that, please? What I'd like to say is that we all know that today the main defaulting companies or non-paying companies are the largest guaranteeing suppliers. So if a number of smaller entities will land in this domain, then I have a very easy answer to that. Recently, a new system of financial guarantees have been adopted. For example, some of the guarantees are provided upfront when you enter into the market, and they're quite significant, such as financial obligations, banking guarantees, and so on and so forth. That's the first thing. And the second, each and every entity cannot make a large influence on the market as compared to large guaranteeing companies. There's smaller plans, for example, but if 20% out of them are not solvent, they will be withdrawn from the market very quickly. And we have already tried and tested this mechanism with the larger companies. So what you should be afraid of is basically the smaller companies rather than larger ones. So this is the message I would like to carry across, and that's why we have created this market council, and that's why we have the supervisory authority to withdraw the status of the participant of the market. So our position is as follows, and that's what we want to make up and running. Now, in accordance with your opinion, and as another question to the Ministry of Energy, what is the phasing of this liberalization? Because even the Udaltsov's model provides for 15%, or probably Karana wrote about that. So first, 15% will be free contracts with the access rights and so on and so forth.
Age-wise character that is an inevitable process, particularly when we merge the market with changing conditions. So if I'm right to understand you, additional developments will be required concerning the question of classifying under categories and assigning to different categories of different rules of the game, because each time restricting the rights of a certain economic entity, we should take into account these principles and their restrictions. So additionally, we'll have to work on the issues. One, certain actors receive certain rules of the game, while the others have different rules of the game. I have another question. There are certain rumors or ideas of setting up a common regulator, unified regulator on the basis of Minister of Energy, Federal Service on tariffs. It is not so actively discussed, but such a possibility is envisaged. What do you think that in principle, on the basis of the authorities of the Minister of Energy and Federal Tariff Service, a unified regulatory body will be set up, which will be the a unified center of decision-making in the industry. Are you sure that it will be on the basis of Federal Tariff Service and Minister of Energy? I especially didn't allow Vitaly Krylov to take part in the discussion. Let us pass on to the discussion concerning legal issues. And of course, that is a provocative question. I would like to remind you of the basic statement. The system and structure of federal authorities, executive authorities in our country is established by the President of the Russian Federation. The President decides to introduce a new structure without such authorities as Minister of Energy and FTS and FAS, available in the practice, government realizing its constitutional law according to the constitutional right according to the law and authority will grant to FAS all the authority of the regulator will have to follow the decisions of the managers. Ivan, are you ready to comment on it? Anastasia was quite right. It seems to me that as to the question of merger, we have to admit it and we'll discuss the problem of sharing the authority between the Federal Tariff Service and the federal level. Here, the prospects will be better. Shall we give the floor to you, Vitaly? That was not my proposal. Everything has already been solved. First, TESS and the Minister of Energy have proposed it, and you are not against. Are there any questions concerning the discussion which we have already had? Toropchin Sergei, I represent Interral Electric Generation Company. Being in this building, we have heard a lot about the prospects that await us in the near future. This is a historical building, so my question will be addressed to Erno and Anastasia. What is your vision of the business program of the I think that in 2113 we are going to discuss how 113% are generated from renewable sources. I personally not just showing my civil position, but as a resident of the planet, I am for the development of the green energy.
First reaction was to go back to 1913 and to think what the laws looked like in 1913 to see whether I could make a comparable leap forward. And I think that energy was not so much of an issue 100 years ago. The Industrial Revolution was just starting. And in 100 years it could very well be that the energy world as we know it is completely different. That we are much easier in generating energy by any movement, for instance, that happens. So I find it difficult to predict. What is certain is, of course, that we then will have a unified European market. So let's keep it at that for the moment. Thank you.
Спасибо за...
Thank you for the question. Any further questions? Let us ask one question, and then we'll move forward. If you allow, I will have a dual question. Michael Karasov, an expert who have been dealing at the governmental department with the issues of electric energy. You say that the government adopts bylaws with exceeding of its authority, interfering into the sphere of civil legal relations. Am I right to understand you in this way? Hence my question. This is really the case. When there was a reform, there was debates as to what the government can do and what relations can be influenced or not influenced by the government. So the model involves amendments to the civil code at the level of the legal norms. We have to remove the competence of the government, or this should be developed at the level of the law on electric energy. That is the question to you and to the Federal Tariff Service. Our reform was aiming at liquidating cross-subsidizing as a negative event related with replacement, and finally it affects the end user. So my question is now, are we fully changing the paradigm? Or we recognize that there is subsidizing as it always existed and it still remains, and the entire model of organizing the wholesale market was aimed at concealing cross-subsidizing. The so-called leading companies of the wholesale market were set up then. Now we are analyzing the theme with cross-subsidizing, and we say that what are we going to do later? Are we recognizing it and working it, or are we taking measures to eliminate cross-subsidizing? Thank you, Mikhail. The ideal is not easily attainable, I believe, and there were significant changes, and probably these were not the rights and duties for the subjects of legal relation. That would be an ideal situation. I also agree with you. Thank you for your question. As for cross-subsidizing, we shouldn't say that it doesn't exist, but we have to reduce the cross-subsidizing. We have to solve that task. The legal assignment of that notion to the law, if we clearly determine the rules and regulations that would regulate that phenomena, in our view, that will make it possible to more correctly, within a shorter period of time, to eliminate that phenomenon. Because cross-subsidizing is related not only with electric energy, it is also related with other sectors and spheres. Thus, we have to solve it in an integrated way. My apologies, I would like to clarify. Cross-subsidizing is not yet defined. It is involved in the law. The reform of electric energy, in fact, as it proceeded, is dealing with that cross-subsidizing. As soon as we explain cross-subsidizing, will disqualify the entire reform, as far as I understand. I will not agree with you. my answer would be quite different. Everyone has his or her own opinion. Dear colleagues, I suggest that now we should pass on to the final part of our discussion, in which Alexander Sitnikov will participate. He will make a presentation on the contradictions in the normative and legal base, and then we'll pass on to the judicial instances and to the procedure of consideration of the judicial disputes with participation of the subject. And the final issue will be the presentation of Oleg Shilokhovost, who will speak about the position of Vice Presidium on all these matters. Alexander, please. Thank you very much for giving the floor. The theme is quite interesting. Preparing for that presentation, I thought, what is the key issue at the market? Because most likely now we have a rather favorable feeling that everything is okay at the market and there are no serious normative problems. They exist, but they are solved by several regulators, and we hope that everything is okay at the market. And probably such a feeling, we could have such a feeling because the market is not homogeneous, it is not a secret. The market comprises at least three parts: wholesale market, retail market, market of services, of natural monopolies, and each market lives following its own laws, and probably there are certain segments of the market that are better protected than other ones. This is a common situation. So in general, the content of the presentation might be divided into certain parts, and we have to determine the place of contractual relations. The question that has already been asked in this conference room: is there any freedom of agreement, and where the state interferes, or the agreements are self-regulated? Self-regulation is also involving participation of the state. Then the main including organizations of technological infrastructure, commercial infrastructure that have also been mentioned today. And in fact, I will remember Leonid Dmitrich, the natural condition of the legal regulation is when the norms of the law support business and economic relations, which in electric energy is not happening and will not happen in near future. Therefore, there is a special slide concerning the restrictions at the electric energy market that exist at present, primarily proceeding from the regular market structure. These are price restrictions. We know that price control related to high concentration of the wholesale and retail market involves the Federal Anti-Monopoly Service. The relevant methodologies and restrictions on profitability are introduced. There is price control on tariffs in the segment of natural monopolies concerning the services for electric energy. There is state regulation of the prices for the population. There is cross-subsidizing, which in near future will be formulated in the contract, and these factors form a very important circumstance. Based on expert true data, the price for energy in 2012 was 55% higher than in the USA. The article describes the pricing for electric energy in the USA, in the European Union. Composite categories introduced, such as the parity of purchasing buying capacity based on the comparison of prices for electric energy. And the sense is that the pressure of the consumers on all market segments will increase, resulting in the waves of debates, which primarily occur at the retail market and sometimes even rise to the wholesale market. For instance, in case of energy streams, there are technological restrictions, norms of the law, and habits that are delegated from the state level. Development of the unified energy structure program of network companies, provision of capacities, forced generation, and the modernization program of energy in 2012-2020 is $36 billion. That is a giant amount, and there are certain forecasts showing that when this program is fully implemented, de facto, there will be one solution for the large generators and consumers of electric energy to develop their own generators, and commercial restrictions, non-solvency, and fluctuation of the demand for electric energy. I will try to show the basic aspects which I would like to focus on since I don't have enough time. Probably the key difference of normative regulation existing in these different segments of wholesale, retail market, and natural monopoly services. The differences are quite apparent. That is, the highest degree of self-regulation, the contract on connection, underway. We have logically subdivided. My apologies for the small letters, but you will get acquainted with the presentation in the proceedings of the period. There are three periods: 6, 8, 8, 11, 8, 11, 13, based on the development of the regulatory basis and prerequisites for conflicts. We have analyzed two markets: monopoly sector on transmission of electric energy, and retail sector that is potentially competitive because there is a high concentration, which is confirmed by the high anti-monopoly control this market. So what does the analysis show? The analysis shows that each time the solution of one problem resulted in emergence of another one. Among the latest examples, there are dozens of examples. We can list just the main judicial conflicts concerning the precedent decisions. For instance, non-regulating calculated procedure of losses and the problem of removing, the attempt of removing that problems. In fact, there is a serious emitted revenue. There are certain disputes related with how the capacity should be paid for, what kinds of tariffs should be used in calculation, what terms of contracts are applicable for a certain period. For instance, there is a contract for transmission of electric energy that was concluded at the end of 2011, and the new regulation emerged in the mid-2012, and so on. In the next table, you can see the debates arising from 2006 to 2013. There are two tables, consumer and supplier, and consumer, the network, and energy company and network. Before the presentation of Mr. Schillerhorst, I can say that there is a long-term period of the last mile problem related with cross-subsidizing. We are waiting for the resolution of vast presidium, and we know that the decision was taken that the mechanism of the last mile has been supported. Please note that this problem, at least among the debates that have been currently considered, comprises two parts. First, propagation of the conditions of the contract concluded for a retrospective period, I mean the lease contract, and the second legal aspect that is actively used in the court judgments, a possibility of leasing out a part of a complicated facility if the resolution of the Presidium assesses only one part, evaluates only one part, and has no opinion concerning the other part. The debates might be carried on for a long period in future.
All these differences that exist in the markets have been outlined by us, and we have put up them in this graph that shows the possible influence of those arguable periods on the tariff growth. We see that the problems arise regularly and they are quite substantial, and the most important is the cost of the problem is hundreds and hundreds of billion rubles. Mainly these problems relate to retail market, to monopoly services, but we see in those three periods that those selling organizations and generating organizations are losing their profits because of the last mile, because of the capacities that they're not capable of selling, and a lot of expenses are made when regulating such problems, and any risks they serve to any risks they hinder the possibility of getting investments back, which also is a substantial problem. Now, wrapping up, if the legal framework is not perfect, if, as we said, very often it only applies to different arguments over certain particular cases, is there a cure for that? We'll be able to resolve some of the arguments in a pre-court way, and for that we need to ensure that the legislation and the energy sector is amended to include the possibility of contract negotiations, and there are a couple of charges that can be brought against the contract. Well, what are the courts mainly look at when they resolve such cases? Dispositive norms. They usually account for the existing cases in the business transactions and the existing norms and regulations. So, unfortunately, our court mechanism is not yet the effective and is not yet a fast way of solving the challenges that arise in the energy sector. If we come back to the graph or to the table that I have shown to you, you see that the that there's always an inconsistency between when the main legal problems will arise and when they will be resolved. So, here we list a couple of instruments or tools that can be used for ensuring normative regulation, such as changing the normative acts, such as arguing the normative acts in the court order, attracting federal regulators, making judicial requisitions or requests. Well, let's live in accordance with the law, let's live in accordance with the regulation, let's live in accordance with the governmental decrees, and only in a number of cases we can be regulated by the orders. Well, we believe it is not possible because definitely, unless we will have individual explanations of those sub-laws and laws, well, actually, there are no sub-laws and laws today because they do not correspond to the criteria of the laws and sub-laws, then different entities will live in a huge mess, and that's why we'll have to leave the opportunity to ensure separate explanations of the norms. Now, what are the possible ways of improving the efficiency of application of law? What's a mega regulator? It's when we have a clear distinction between the authorities of various regulators, when the specific acts for this market are published, then preparation of extended cover letters to various norms and regulations that are being adopted and their subsequent publication, especially taking into account the results of public hearings and tertiary courts. That's another opportunity. Thank you, Alexander. I vote for the Presidium Decree, Industrial Presidium Decree, and this is the question I would like to address to Mr. Shilahvost, because the Higher Court of Arbitration of Russia has recently become a body that plays its role in various industries. We now spoke at the tax roundtable about the High Court of Arbitration role. Now, Oleg, what do you abide by when you make decisions? What are the most interesting cases that the High Court of Arbitration deals with? So please tell us about your experience. Actually, I'm going to proceed, but I was going to ask about the time. How much time am I allotted? As long as you need, 10 or 15 minutes at least. Oh, thank you so much. From one point, it's very easy for me to talk in here because a lot of the things that I was getting ready to explain to you and to which I was preparing myself, unfortunately, the microphone is not operating. A lot that I was planning to tell you today has already been voiced by my other colleagues, and I need just to note that the presentations of the representatives of the Ministry of Energy, the presentations of the representatives of the Federal Anti-Monopoly Service were very good and quite explicit. The only thing I'd like to relieve me of is the necessity to comment this topic of the last mile, because the motivations that the Presidium had used were not published. So we know the position of the Presidium, we know the outcomes of their session, and we will continue to implement the decisions that were made. But what I would like to dwell upon is that the number of court cases in the area of energy for the last 10 years have grown up from 2% to almost 8%, which demonstrates clearly the fact that apart from certain objective reasons for that, there are subjective reasons. And what are those subjective reasons? Well, I would probably attribute to that the imperfections in our legislation, just in principle, I would like to describe the picture in general without going far into details. Now, as for the court practice, as for the problems in here, well, in brief, the main problem is having the benefit of using public and law and various law instruments. Our legislator, well, and by legislator I mean those who adopt new laws and those who do sub-laws, those legislators, they very often forget, or it may be that they just never had the time to adapt the civil code to the existing public law limitations. This is the main problem, because we have very nice norms that state what authorities are there for limiting the rights and legal interests of those participants of business transactions, but what is not very explicit is how those participants of commercial transactions, I mean the players of the energy markets, can defend and protect their rights. Moreover, the usage of traditional legal instruments is highly difficult because the law is not perfect, as I said already. Another problem, as far as legislation is concerned, is that we have a very high, inadmissible even, share of norms that just cover the technical specifications or technicalities, such as what kind of termination box should be used for what kind of wire. Dear colleagues, I may express my own opinion in here, but this I cannot read. This is not the norm of law. This is just a guideline for technical operations. Well, I believe that this is not the place for technicalities. And I'm not being snobbish in here. I'm not acting as a lawyer who doesn't want to bore himself with all the technicalities, engineering technicalities. I do appreciate and I do understand that having those engineering technicalities as a norm of law increases the number of court cases, because if it's the norm of law, it means that any dispute can only be resolved by applying and referring to the court. On the other hand, having those technical rules prescribed in the norms very often makes it difficult and sometimes makes it impossible to resolve the case, because when you deal with issues of a single interpretation of different norms of laws, it's quite difficult when these norms of laws are overburdened with technical specifications. Now, it doesn't necessarily mean that there are no problems in the legislation, or we don't see those problems in the legislation, but mainly it is it's the demonstration of the fact that our regulators are not entitled or not vested with authority to assess such technicalities and their application. Another thing that I would like to say: codification of the ever-changing legislation has gone completely out of control. I know that today it's very easy to just press the button and all legal history and all previous cases would be downloaded onto our computer screens, but having this opportunity to refer to any legal act does not relieve the responsible authorities, the responsible bodies, the bodies that have to follow up this or that normative act to trace and to ensure that the norms of a much higher level are implemented to the norms of the lower level in due time. Otherwise, we will be faced with a situation that is already explained by our colleagues from the Minister of Energy, when the number of court cases is growing up. Now, wrapping this section of my presentation up, I would like to criticize one of the means that is used today in our legal work, that when a new change is required, or even a cardinal and significant changes are required into legal regulation of these or that relationships, our legislators prefer to prepare and to introduce a new act, but not to pinpoint those clauses that require amendments or changes. In our case, that brings in even more disputes, because the participants of the market, the business participants, they start looking for former editions of the acts. They don't find some of the things in them. They go to the courts and they try to protect their rights by making references to the fact that early on we had such kind of clauses, now they're no longer available, and so on and so forth. Now, if time permits, I would like to tell a few words about the contents of those drawbacks of the legislation that I see. What I believe is those drawbacks mainly are due to the fact that there is a disconnect between private and public law, and very often if you change the rules in the game on the way, on the road, it leads to grave consequences, because regulating authorities very often strive to streamline the composition of the players or the participants of the commercial transactions. However, it's good when the dates are being postponed to much further ends, but very often different players get to know about the changes in the law only the day after tomorrow, while they were introduced yesterday. So I think that this has to be, there should be an end to that, because that brings additional disputes where they shouldn't be at all. Our legislators can be of any level, but we must work on the presumption that they are competent, that they're experts. We believe that the regulators should not be guided by the wish to introduce a mess in the lives of the regulated entities. Now, another topic I would like to say, it's the market interests of the participants of the commercial exchanges or transactions. I mean, especially those players that are the regulated organizations, those organizations that are being introduced certain limitations to, or their partners. My opinion is our legislator, when he puts the participants of the market into a deadlock, because these participants in the market cannot ignore the limitations that are being posed by the public law models, especially as far as compensations are concerned, how to overcome the consequences of those regulatory measures. Well, that has to be done by the participants themselves. It means that when you don't live up to the limitations, well, it's impossible, but when you want to compensate for your losses, it can only be done if you are fast and if you are collecting all the necessary evidence, which is enough to support this or that.
It seems to me that there is also a topic for consideration. And finally, I Probably I'm the only lawyer in this conference room who doesn't share the viewpoint concerning the capacities. I understand well enough that the wonderful norms that concern trading capacities are based on well-devised and thought-of economic models. But please note that whatever the models that would underlie these concepts, that doesn't mean that it is necessary to reflect the economic models and the norms of the civil law. If these are purchase and sales, if these are deliveries, we cannot allow ourselves to have a discussion whether this is a commodity or not. We should either, the legislators should either invent some other means of take into account the interests that may get possible to take into account trading capacities, or we should eliminate such understanding as trading, because trading in air, well, we could also trade in frequency or in light, which would inevitably result in natural participation of the participants of the market relations who know that the goods that are paid for should be delivered. There might be different opinions concerning the counting, but when we pay for something that is not supplied or delivered, that results in well-grounded problems among the law enforcement authorities. And I'm misusing your time. And finally, I would like to state that in addition to the fine professional issues that have been discussed here today, which doubtless are on our agenda, I think that speaking about the legislative regulation of relations in the sphere of electric energy, we should take into account the issue of adaptation of the civil legal norms and civil legal institutions to these complicated issues, and not imposing the restrictions on these institutions or elimination of their practical use. Thank you for your attention. Thank you, Oleg Yurievich. I would like to tell you that after your presentation, not a single person has left this conference room, so probably we should think about whether capacity is a commodity or not. And thus we have summed up the legal results, so to say, of our discussion. And practically everything has been covered and characterized in respect of the legal normative regulation in the industry. And to conclude, I would like to say that in the course of further movement forward, while choosing certain means of development in the industry, including the legal model, we have generally to think about the system, not only about the principles of building, but about the consequences of implementation of the new principles. We shouldn't lose the systematic links in electric energy that are available, because many people say that super liberalization might lead to building own generation and removal of withdrawal of certain consumers from the general network. It is also necessary under the development of the legal normative norms to be more dynamic for the sectoral industries, departments and regulators, and to develop the existent norms and to adopt them, because the notion of the social norm has already been introduced, but not many people knew that it existed in the current legislation, and they regarded it as a novelty of the current period. And as for liberalization of the markets, probably it should be noted, and I see the understanding among the participants of the discussion, that liberalization should be stage-wise. Of course, we need a competitive sector. However, all the accompanying normative and legal acts containing, as was mentioned by Oleg, the norms of a law, not just technical characteristics, should be adopted and accepted, and the introduction of a more liberal model should be hedged on all the sides, including the normative legal level, and it should defend both producers and consumers and all other participants of the electric energy market, in brackets capacities. Thank you very much for your interest in discussion. And I would like to thank the speakers and the colleagues who attended our conference. And I hope that next year, I don't know whether we are going to convene this round table, but we hope that there will be an interesting discussion and with presentation of some new results. Thank you.